Hello, my name is David Mayo, and I'm from the California Institute of Technology, and I'd like to talk to you for a few minutes about a question I get asked fairly frequently, which is what is the difference between a grant and a contract? And there are really two ways of approaching this, the answer to this question. One is the legal definition, and the other one is the federal definition. And they aren't mutually exclusive, and in some cases they overlap. But really you need to figure out what are you looking for before you can answer the question. So for example, from a legal point of view, if you have a document that includes an exchange of something of value, an agreement that exchanges something of value, the parties are competent, and several other characteristics that are based in law, then you have a legally enforceable contract. That has nothing to do with whether it's a grant or a contract. It has to do with whether it's legally enforceable and legally considered a contract. So a gift that has those characteristics, for example, a gift, it may be called a gift, but it has an exchange of promises, there are obligations imposed on the parties, that is legally a contract, regardless of what it says at the top. Same thing if it says grant, it's still a contract. But if you're really talking about the federal government's perspective on is it a grant or a contract, the difference has to do with which federal pot of money the funding comes out of. Does it come out of the financial assistance pot of money, or does it come out of the procurement pot of money? Financial assistance, the transactions the government uses are grants and cooperative agreements. When the government is buying something via procurement funds, then it issues a contract. So to give you some more characteristics about those distinctions, the government uses financial assistance money in order to support a public program or a public need. The government uses a contract or its procurement money in order to buy something that the government needs in order to operate or fulfill part of its mission. So it can use two different pots of money. Another aspect of this, when the government pays for research, whether it pays for it through a grant cooperative agreement or a contract, it is doing it from two different points of view. So if you take the route of financial assistance via a grant or cooperative agreement, the government has decided to make a pot of money available to support a particular program, a particular area of research, whatever it might be, and it's looking for individuals, institutions, whoever, to submit proposals so that it can get the best science done or the best project. It's looking at the value of what the likely result is going to be to further that public need. On the other hand, in a contract situation, the government already knows what it wants done. It's not looking for good ideas necessarily. It's looking for, it's created the idea itself. It's now looking for who can do it at the best price as quickly as possible. I mean, there are other characteristics come into play, but that's what it's looking for. So the government, in one sense, is buying research that it's determined it needs to fulfill its mission. In the other case, the government is supporting research. And that is basically the difference from a federal point of view between a grant and a contract. Thank you.
That's really good there.